All right, folks, welcome to the ELRLE5 court practice. So today I'm going to spend some time to show you how to find some documentations which you're going to use in the court. We're not talking about finding the law, okay, because that's something that you should already find. Right now, in this stage, you're looking for something which which can help you to practice in the inside of the court. All right, so let's start. So here's agenda. We'll first discuss the autonomy of the lawsuit. Then we will move on to find where can we find the to file a court documentations, and where we can find the court rules. And then this is the juicy part. Where we can find all the important helpful sources about litigation process, such as practice guides, form books, pattern jury instructions. And then we will look at the practice manual specific for a lawsuit, so such as general forms and text-specific forms. So here, this is the autonomy of the lawsuit, which I believe you all should be familiar with. But let me go over with them so that you can refresh your memory. First step is we got the research project, and then we are underlying some facts. We do some fact finding. And then we move on to the investigation, which we will talk about each of the part in next step. Right. Then we will move on to file the motion to petition or complaint to the court, and then the opposing party, they will file the answer if they want, and then they will have the discovery. So we have multiple discovery tools, and we can file the different motions to do many things in the discovery phase. And once we get a discovery, we can file the motions for the discovery. We can file the motions for the dispositive, which we'll talk about very soon. And then we move on to the pretrial phase, where we can try to exclude some evidence from the, even if they are discoverable, but we don't want to have those evidence introduced into the court or in the formal trial or admitted to the formal trial. And then we move on to the formal trial. And then after the trial, we may have the different proceedings of appeal, right? So this is how the autonomy of the lawsuit of the big picture. Let's check them one by one in more detail. Excuse me. So first step is finding the underlying facts. Once you get the documentations from your clients, you read them, you identify some cause of actions. So this is where you start, right? You want to identify first cause of actions, because those are those information you need to build up your claims to decide whether your clients have a claim or not. And potentially you also want to find, is there any defenses? Also, before you move on, you also want to check the statute of limitation, because this is a deal breaker, right? Even if your clients got the case, very likely, but the statute of limitation may potentially bar clients for any proceedings moving on, right? And then once you get that, you can move on to have the investigation. This is more about the internal administrative part in your firm. So you can prepare for the fee agreement, for example, all the multiple type of fee agreement, contingent or fixed, where you may want to prepare an intake checklist. Those documentations, your law firm should provide you a sample, so you don't need to do it by yourself. But I mean, if you choose to solo practice, well, probably you want to prepare those documentations for yourself. And then we move on. We may want to file the petitions or the complaint, right? So there are many writing samples out there, existing samples. From some of the court, they offered some formal samples so that the parties can use directly. Some of the court, they do not offer the model samples. So in that case, we can just use the legal sample forms offered by the other professionals. So we don't have to create wheel every single time. We don't have to write everything from scratch by ourselves every single time. So steal other people's wisdom, and also this is why legal forms are here. So we can use them in a red matter. And then we have the jury request. If we want to bring the case as a jury trial, we want to make that such a request. And also we want to find out where to file, right? And then we want to provide the services to the opposing party. And then the opposing party, they may choose to answer, they may choose to keep silent, but if they choose to answer, same thing, they will need to file the answers to the court. They got to draft the answer, but again, they don't need to draft everything from scratch. They can rely on those model samples or the model forms or the sample forms. Then we move on to the discovery phase. So we have many discovery tools. So hopefully you still remember them in the 1L civil practice. Interrogatories, that's a standard question for writing question, and you ask other people to answer. And there's always a maximum questions you can ask in one interrogatories. And we also have depositions. That's a question like interview type of deposition under affidavit, and this is why they can be used as evidence. Those depositions are always in the recording. In the past, they are always in the transcript. There's a maximum time limit for each of the deposition. You cannot make it like 20 hours or 15 hours in one deposition. And another tool is request for production of documentations. So this is quite common when we believe the opposing party have some documentations which may be related to the case. We can make such a request, and of course the request got to be related to the case, and the cost of the reproduction must be reasonable or not so unduly burdened. Like you don't want to ask the opposing party to produce millions of emails, which just impossible, and they will try to avoid to protect such massive number of documentations. And also you can request for admission. So you basically just ask the opposing party to admit something. And if we want to get the third party as a testimony or third party witness involved, we can either ask the court to issue a subpoena to bring the third party to the case to the court to offer the testimony, or we can have this third party to provide the affidavits under oath. So these are formal evidence, excuse me. And then we have the multiple motions we can use in discovery phase. So we can use a motion to compel the other party to produce something or not. A lot of times people, they don't want to cooperate. So we have to use this motion to force them to produce something or share some information. And the opposing counsel, they can say they want to have the motion to they don't want to produce those information, so they will file a motion to quash. Of course, all of those motions are subject to the court discretion. The court, they can say, well, I grant you this motion, well, move on. I deny you this motion, so period. So it's a judge's discretion. It's not like we have the rights. And another thing is motion in alignment. This one is something that we try to ask the court to exclude something to exclude some evidence from the trial, from the court, even if something is contingent, right? And also we got the protective orders. This one is which is quite common. So we want to the evidence may be contingent for some reason, maybe disappear for some reason. So we want to file this. We want to get this protective order right now to protect this information as evidence, so it will not pass away. And then for the dispositive motions, which I mean, you should be very familiar with these two types of motions: motion to dismiss, motion for summary judgment. So motion to dismiss, they are based on the affirmative defenses. So statute of limitations or other like wrongful jurisdictions, etc. So they are not just, they do not dealing with the evidence, they're just dealing with the fact here or the dispute here. And motion for summary judgment, no sincere dispute among the parties. And this is where they will, if you got those two cases here, motions here, if you so you can file them before start the formal trial or the formal case. So this one, many people they will try to start with these two motions first, and then we have the motion for a pretrial proceedings. For in the pretrial, we majorly have two motions. Motion one is motion for continuance. That means our scheduled trial time does not work for us for some reason. Of course, we got to explain to the judge what the reason is, and the judge has discretion to reschedule the trial. Or we want to we can file a motion to amend the pleading. Of course, it's a judge's discretion whether they allow you to amend the pleading or not. And then we move on to the trial stage. So in this part, we can have the trial court to, because we can request the jury trial. Once we request the jury trial, the jury will deliver the final verdict, aka whether all the elements of the claim or defenses are met. Right. So this is what we call the jury charge. Excuse me. And in Texas, all the parties, both parties, they can provide a jury charge to the judge, and the judge, the judge will just deliver the final jury instructions to the jury, but the judge will check both you and Johnny's submitted a jury charge, and the judge can choose to use either one of yours, or the judge can decide to draft his or her edition of the jury instruction. So this is where it's important, because we want to twist the word so that the jury instruction, that's the final stage for the trial, right? That's a final strike for the trial, to make sure that to get some chance for us to win this case. This is where we want to twist the language so that the jury instruction give our clients some benefit. And the next step is voir dire. This is a jury selection. So we hopefully you still remember that in civil prose. So we can challenge or cross some jurors out of the jury for a reason or without a reason. If that's the common cause of the removing juror is they have some prejudice, like bias or conflict of interest, etc. And then the trial end, the jury will issue the verdict, and the judge confirm the verdict, and then the case is of course one party will not be happy with the decision, with the verdict, so they will appeal the case. So that's where they got to file a notice of appeal, and of course they want to they want to also submit a briefs. So you can see those are the proceedings. It involves many documentations, many procedure issues, and those documentations, procedures, you don't have to create a wheel by yourself. There are many available resources out there on Westlaw and LexisNexis, which you can use directly. And of course, you want to use them in a smart manner and carefully manner, so it can make your practice much more productive. So for the informations where to file, so if that's a federal court, so we don't have any other choice. So we are using PACER. So PACER is a federal court e-filing system. And you got to enter your bar license, and you got to first be admitted to that court, and then enter your bar license, and each of the filing will you can submit the filings to that court through Pacer. And if you are in Texas, so most of the Texas court right now, they mandate the e-filing system. We have several e-filing systems from the different commercial providers. Each of the filing platform can deliver your filing to the court. But as you can see, not all the Texas court they mandate the e-filing. We have the Supreme Court, Court of Criminal Appeals, the two highest court of Texas. We have all of the Court of Appeals of Texas, and all district and county courts. You see, we are missing three types of courts here. We are missing the Court of Probate. We are missing the municipal court. We are missing the Court of Peace. Right? Their jurisdictions is a little bit smaller, so this just based on the court discretion whether they want to enforce the mandatory e-filing or not. But for those court listed here, they mandate the e-filing. If you are attorney, if you're pro se, you don't have the e-filing. And if you're looking for court rules, well, just go to the court clerk, just go to the court website. And unless you are looking for some case laws on the based on the court rules, you don't need to check Westlaw and LexisNexis. Just go to the court website and print them out, and keep a copy at your hand. So this can help you to solve most of the problems, because most of the court they have quite similar rules. Some court they may have more detailed rules. For example, they may set the maximum pages for the for a motion, for a brief, for a pleading. So they can some court they set the maximum numbers of words in a single document. So those kind of things you want to double check before you working in that court. And here we got the juicy part: helpful resources. We have multiple helpful resources, and most of them they're on Westlaw and LexisNexis, which has been used by attorneys for a long time. So first we got the practice guides and the American jurisprudence trials, American jurisprudence proof of facts. Those are the general practice guides, which does not fixed into a specific jurisdiction or a practice matter. We also have the federal level of cause of actions. But we also have the Texas-based materials. So Texas practice guides. This copy is only available on Westlaw, because this is published by Westlaw. But this is published by West, which is a parent company of Westlaw. And then we have the Texas-based materials, Texas practice series. We already talked about that. O'Connor's our best friend of O'Connor, which is only available on Westlaw, and Dorsenio, which is only available in Lexis. This is a Texas litigation guide, which is a one-stop search for all the Texas civil law practice, including, for example, labor law, education, and employment law, torts, and corporation, family law. So it doesn't cover constitutional law or the criminal law, criminal procedure, but this is why Dorsenio is one-stop research. There's not too many titles on Lexis when they have Dorsenio, but on Westlaw, they do have diversified titles, including O'Connor, Texas practice series, etc. So let me show my let me run the demo at the very last minute. So let's go over those materials right now, one by one. Then we have the form books. So those are the form books in the past where the attorney used. So what are the legal forms? They are writing samples. So motions and all the briefs, all the pleadings, answers. You don't need to write everything by yourself. And there's certain things like the formatting thing. You don't need to worry about that by yourself. Just follow the standard, follow the listed documentations, standard forms on those from those documentations. So a lot of them, they would just leave the party's name, specific case, the case specific informations blank. So for the rest of the information, they are quite standard. You don't need to like worry about or like think hard how to draft those documentations. And I will show you how to find those forms on Mastodon and LexNexus. State Bar of Texas, we have many practice materials. So here's a list of practice materials. They are typically a secondary source. Of course, all of these informations, they are secondary source, and some of them, they can be very helpful. So where you can find them, as you can see, they are just topic-based materials. And how can I find them? Well, go to Texas Bar CLE. This is the website. And then you can log in. You got to first create your personal account, but with your TTU email. And because you are TTU affiliated personnel, your TTU email can make sure that you create a free account, so you can use it freely. You can check as many resources as you want on this Texas Bar CLE website without any charge. And of course, in the future, when you get licensed in Texas, you want to use your law firm's email to log in. So give and take. Jury instructions. So we have the Texas, we have, this is important. We have the Texas pattern jury charges, both in civil jury charges and the criminal pattern jury charges. So those are the charges that you can rely on to draft your jury charge. You submit it to the judge. Right. And because this is our last shot in the trial court to fight for our case, hopefully the judge, they can use my jury charge. That means, of course, my word will tend to give my clients some advantages. So, but again, writing them, you don't need to like tailor them by yourself or think them by yourself hardly. If you want to do that, great. And sometimes we have to do it because we want to tailor our jury charges by ourselves, because our case are specific, right? And the judge will make the final decision. What kinds of jury instruction she will give to the jury. And these two titles, criminal pattern jury charge and civil pattern jury charge, has been used by attorneys for a long time, and they are both available on Mastodon and LexNexus. And then underlying facts and investigation. So you're looking for the substantive of law, right? You're looking for the statute of limitation, cause of actions. Well, we have many resources here. I will not read them one by one. For the fee agreements, for the client intake checklist, for those internal law firm, internal based materials, we also got some legal forms. And when you use those databases, you want to search them by title, or keyword search works, but they also provide us a title section, which you can find in here. So this TI represents as an abbreviation of title, and parentheses. And under the parentheses, you are searching the fee within the same sentence of agreement. So /s is a connector, which means the keyword 1 is in the same sentence with keyword B. Right now, you don't need to worry about those like these connectors too much, because if you we have another session, ER session about the Boolean search, which tells you how to use those connectors, draft the keywords in a more effective manner, right? And similarly, if you're looking for the client's intent, we do the same thing, searching for the title and searching for the keywords client within the same sentence with intake. If you're looking for the petition, complaints, or answers, we do the same thing. Go to those outstanding secondary sources. And you don't need to draft everything by yourself. Of course, your firm should provide you some sample documentations to save money, because not every time you don't want to use Westlaw and LexisNexis to find forms every single time, right? And it's not so necessary. So keep a record in your hand so that you can use it in the future. This is what the most often they do. And you can find the filings, you can find the services, etc. And also you can search the documentation type, because right now you're searching for the petition or complaint or answers, right? For a specific type of documentation. So this time we use a different segment. We call that segment. You will see what do I mean segment in the secondary sources. So this is a documentation. This DT represents the documentation. So we are searching the complaint as a documentation. And then we have a connector AND, which combines documentation complaint here with all the following keywords. So you know what these keywords represent for, right? Premises within the same sentence with liability. So this whole searching string means we are searching a complaint as a documentation type. And in this complaint, premises is within the same sentence with liability, with the keywords. And this is how we do the research. You can see it's a little bit different than the keyword search, just like a complaint space, premises space, liability. You will see the difference very soon. Answers, same legal information, go to the same place. Again, you don't need to remember all this information, all these forms right now to keep put them in the deeply remember them in your head. No, you don't need to do that. Just save this slide as for example as a record. So in the future, when you need to find something which you may use in the court, well, you can go back to check this slide, right? And once you start to practice, probably after 1 or 2 months, you know where the most commonly used legal forms or writing samples where you can find them. So you don't need to use this slide anymore. Discovery, we do the same thing. We have many outstanding titles on federal level, on state level. Sometimes you can find the specific like practice-based forms, but you don't need to remember them. Just I will show you the general searching feature. They are quite similar. On Westlaw, they are grouped together. So you don't need to be distracted or self-worry about where you can find them. And if you're looking for the written deposition, subpoena, affidavits, indexes, you can also find it here. Right. Motions, again, you can still find the discovery motions, the dispositive motions, you can still find those titles in those titles, right? And how to use them, all of those forms, they work exact same way, which I will show you in the next few minutes. Pre-trial, again, some outstanding titles, how to use them, they work in the same way, right? And once you are in the trial, you want to use jury instructions for the pattern jury charges in civil, in criminal. They both Westlaw and LexisNexis, they have it. And if you want to have a challenge the idea, well, you can also get the more detailed procedure here. Appeal, we got the same thing, some outstanding documentations, right? And before I let you go to take the Blackboard post-assessment, excuse me, let me share my Westlaw and LexisNexis with you so that you can see how do they look like. So here's Westlaw. Let's say we're looking for the secondary sources. You know how to find the secondary sources. Let's say you're looking for the text-based materials. So for this type, if you know which material you want to use, you can browse them by their name. Or if you want, you can go to find their publication series by O'Connor, SBT, or the text practice guide, text practice series, right? As we just seen in the slides. or you can browse the table of content here. If you're looking for the jury instructions, let's say you can select it here, and then it will lead you to the text jurisprudence, the text jury charges here. So we have the both civil and criminal charges, jury charges, and how to use them. They are classic secondary source, right? We know what we got to do in the secondary source. We can run a keyword search. We can browse the table of content. If there's any index here, we can also use index, right? So those are our 3 tools that we already learned in 1L. I will not show you how to use them to waste your time. And then if you're looking for the forms, those are the secondary sources. They carry some forms, but they do not specialize on the legal forms. And essentially they are secondary sources which help you to what the law is, right? And lead you to the law. But if you're looking for the writing samples, aka legal forms, on that stuff, you can find it here, right? Go to forms. Let's say you are in Texas. You can browse them by the different documentations. Those are the federal level general legal forms, and if you can browse them by topic. If you're looking for the Texas legal forms, go to Texas, and you can browse them by topic. But you can also find the text-based practice legal forms. So let's say we want to find Texas legal forms. Let's say we go to advanced search, right? So this is where I mean title. You still remember the TI, right? You remember the TI. This one in let's see, the same sentence of this is what we see in the slide, right? So now we don't need to use it, because as long as you can find it, go to the advanced search, you can search the keywords from the title. So I don't need to use that TI like segment. So fee in the same sentence with agreement. So I'm searching fee agreement within the same sentence, just within the title of the documentations. And let's say we are looking for, we don't know the specific type of forms. So let's just run a generic search. So we have many type of fee agreement. Your law firm, again, your law firm should provide you such a fee agreement. But in case you want to tailor it by yourself, well, here are the sample of agreement. Let's open one of them to check how does it look like. Unilateral consultant agreement, unilateral fee provision. So this is just one provision, and let's find a more comprehensive form. If let's see if we can find that. This is a Social Security disability claims. Let's find some other practicing areas. And also be flexible when you use those filters, right? Always use filters to narrow down your search. You don't want to read this almost 250. But let's say we apply the filters, and one we find something. So attorney's fees for this part. This is just one section, which is not ideal, but let's find something else. Let's find taxes. Agreement to joint representation and fee sharing, agreement to hold homeless forms. So we got a forms, right? Flat fee or hourly fee. This is a sample documentation, and you want to use it. This is just one sample. If you want, you can check the other samples out there. There are many samples. When you use these writing samples, be smart, because this one is great because it leaves all the important things in the highlighted here in a different font, right? But sometimes the legal firm will not provide you those highlight, and sometimes it's just if you don't pay special attention, you just copy and paste everything, And essentially, you just made some use some unnecessary information in your for clients, right? Because clients are clients, they are different. Sometimes we want to provide something different. So be careful when you use those writing samples on Westlaw and LexNext. You don't want to just copy and paste everything. You are the one to make the subjective decision, which part do you want to use, right? And this is Westlaw, right? And how do you find the legal forms? If let's go back to the text forms. If you don't want to use this this approach, keyword search, you can go to browse them in your find a leading title, for example, text legal practice forms, and then browse it by type of content. Let's say we have the family law here, we have the child custody and support, and then we have the child support, and then you want to find the form. Read the form here, right? And check them one by one. If you find them something you want to use, read it carefully and try to find some alternative forms on Westlaw or LexNext. So compare them until you decide which part do you want to use from this form, which part do you want to use that from that form. You have a lot of flexibility. So this is the Westlaw. Let's go to LexNext. So same way, if you're looking for the general practice materials, go to secondary sources. You know where to find them. And if you're looking for the national titles, we have those ALR, etc. If you're looking for the text-based materials, you'll go to text. Again, like I already mentioned, because in text we have decennial, so it does not cover. In secondary sources, we don't have too many secondary sources in Lexis. But we do have the criminal pattern jury charges and civil pattern jury charges, right? And we also have another legal form. How to use them? We do the same thing, right? Let's say we are using this criminal pattern jury. We don't have index, but still keyword search and type of content. Let's say this time I just want to browse the type of content by myself. So let's say I want to get a let's say general charge, and there's no special charges, let's say. So limit of use of evidence, you want to have to submit this charge, a jury charge to the judge, and you think this is important to your case. For example, limit of use of evidence. So this is a writing sample that you can use directly, and it provides you the so here insert the instruction for underlying offenses, and here you can use most of the word, I believe, in your case, so you don't need to draft everything by yourself. And also it provides you the fundamental all the primary source you need to use for this case, right? And this is just one copy of the one writing sample of the jury instruction for the jury pattern jury charge for the limited use of evidence, right? I suggest you to find some related materials to compare them and then decide which one do you want to use. Lexis, if you want to find writing samples, so similar to Westlaw, go to samples, right? And then if you're looking for the topic-based samples, well, just go to here. If you're looking for the jurisdiction-based writing samples, go to Texas, for example. And then if you know your practice area, just go ahead. If you don't know, if the practice area does not matter, well, it's way too broad, that's fine. Let's run the keyword search here, right? Advanced search and keyword search. So let's see. Again, we are looking for the title, fee agreement. So we are searching for the title, fee agreement within the same sentence, these two keywords. And let's check what we have. We only have 9 results, right? General contingent fee agreement. This one comes from Decennial, which is great. So let's check how does it looks like. So this one seems to be the ideal writing sample you can use without any hesitation. So every part you want to enter is left in blank, right? And you can, of course, you get to change those percentages by yourself based on your case and based on your client, based on law firm. But this is a quite solid writing samples. So you can see if I don't know how many pages does it have, but I would say it's more than 5 pages in print. So you don't want to write these 5 pages of like contingent fee agreement by yourself, right? So take advantage of these available resources. And that's what you will use and practice in your after class assessment. So you will have 2 weeks to complete this assessment, and you can find the assessment on Blackboard. If you have any questions about this session, about the demonstration, about how to find the forms, about the post-class assessment, do not hesitate to contact me. Thank you for your time.